Hello and welcome to the Kenneth Vercammen Law Office Legal Podcast. This edition we're looking at some criminal cases, and here it's a New Jersey Supreme Court case of dealing with, it's really domestic violence, AC versus RS. They have to use, in the domestic violence cases, they got to use initials. Here, a final restraining order was reversed on the grounds of cyber-harassment under the statute because the defendant did not commit a lewd act by bragging about her sexual prowess and did not threaten to inflict injury. So the facts here: defendant appealed from a FRO, final protective order, entered against her and in favor of plaintiff pursuant to the Victims Assistance and Survivor Protection Act. The trial court had concluded that the defendant violated this act by, amongst other, committing cyber harassment when she sent plaintiff a text message containing lewd language and threatened to contact plaintiff's employer concerning plaintiff's relationship with defendant's husband. On appeal, the Supreme Court reversed. The Supreme Court said the record did not support a finding of cyber harassment under the statute because the defendant did not commit a lewd act by bragging about her sexual prowess and did not threaten to inflict injury or harm or commit a crime against plaintiff's property. The court did note that they rejected a defendant's assertion that a text message was not a communication because, in fact, a text message is. Text messages can be sent via a cellular network or internet, and they are a form of online communications. Given the fact that there's texting, even though the statute itself does not say texting, the Supreme Court concludes the legislature did not intend to exclude text messages from the type of online communication. The Supreme Court also held that a threat against one's job by contacting an employer can be a form of a threat against property under one of the statutes. However, the defendant did not violate the statute because the record itself was devoid of any evidence showing that the defendant, intended to do anything other than inform plaintiff's employer about the relationship between plaintiff and defendant's husband, which was not the sort of contact actionable. That's AC versus RC. The full opinion is on the Vercammen blog, Criminal Cases, even though it's not a criminal case. And for representation in domestic violence cases, visit website njlaws.com or contact Ken Vercammen's office at 732-572-0500. Thank you.